morning to all present here, respected principal sir, honorable judges, esteemed faculty members, dear participants and my fellow friends.
It is my proud privilege to welcome you all to day 2 of the internal Moot Court competition 2025-26 organized by Shahaji Law College, Kolhapur.
Today marks the culmination of rigorous preparation, intellectual discipline and courtroom advocacy, the final round of this prestigious internal Moot Court competition.
The internal Moot Court competition is a cornerstone of practical legal education at our institution.
This year, the competition witnessed exceptional participation and academic enthusiasm.
A total of 275 participants,
182 participants in English category,
93 participants in Marathi category.
Proceedings were conducted across 7 court halls,
which was assisted by 7 external judge assessors along with 7 internal professor assessors.
After intense preliminary rounds, 14 participants have emerged and qualified for today's final round.
We are deeply honored by the presence of our esteemed judge whose experience and guidance elevate the academic standards of this competition.
On behalf of Shahaji Law College, I extend a respectful and heartfelt welcome to our honorable judge and assessors.
I now invite Chandan Oza from 3rd NLC to introduce our honorable guest.
Good morning, respected chief guest, principal sir, senior professor Dr. MC Sheikh sir, and everyone present here. It is a great opportunity for me to introduce the learned judge for today's Moot Court competition. We are honored to have us Advocate Deep Lakshmi Pendekar ma'am, a senior and respected member of the bar. Ma'am is enrolled with the Bar Council of Maharashtra and Goa in 1995 with over 30 years of continuous legal practice. Ma'am has extensive experience in civil, family, criminal, revenue and consumer law. Ma'am has successfully handled more than 1,000 cases and appeared in more than 500 matters before specialized tribunals including the Maharashtra Revenue Tribunal, Consumer Forums and Charity Commissioner Courts. Ma'am is renowned for courtroom advocacy, precise legal drafting and conveyancing, having finalized 1,000+ legal documents. Ma'am has actively contributed to the legal profession through ethical practice and pro bono legal services. Her presence today is a valuable opportunity for all participants to learn from her vast experience and legal expertise. We are truly privileged to have Ma'am preside as judge for today's competition. Thank you.
For introducing our honorable guest, as a mark of respect and gratitude, we request our dignitaries to kindly accept a token of appreciation from Shahaji Law College.
I request Principal Praveen Patil sir to felicitate our respected chief guest.
थँक्स शेख सर देणार आहे तिला सांग.
Today, the finest teams stand before us. To all the finalists, your journey to this stage reflects dedication, discipline and determination.
May your submissions be clear, your authorities be strong and your advocacy impactful. On behalf of Shahaji Law College, I wish you all the very best for today's final round.
Time rule for today's competition is 5+2, that is total 7 minutes.
Now, with the permission of Honorable Ladyship Advocate Deep Lakshmi Pendekar ma'am, can we please proceed with the proceedings of today's Moot Court competition? Thank you, ma'am.
आज आपल्या समोर वादीचा वकील या नात्याने उभे आहेत. माझ्या मूळ युक्तिवादास सुरुवात करण्यापूर्वी या केस संदर्भातील थोडक्यात घटनाक्रम आपल्यासमोर मांडण्याची परवानगी मागत आहे. अपीलकर्ता आणि प्रतिवादी यांच्यातील विवाह 20/2/2008 रोजी झाला होता. या विवाहातून त्यांना एका मुलीचा जन्म झाला. वैवाहिक मतभेदामुळे अपीलकर्त्याने 7 जुलै 2017 रोजी कुटुंब न्यायालय भटिंडा येथे हिंदू विवाह कायदा 1955च्या कलम 13 अंतर्गत घटस्फोट याचिका दाखल केली. घटस्फोट याचिकेत सुधारणा करून 3 एप्रिल 2018 रोजी पुन्हा दाखल करण्यात आली. अपील करण्यात त्याचे मुख्य तपासनीस म्हणून शपथपत्र सादर केले. त्यानंतर प्रतिवादीने अर्जाचा विरोध केला कारण इलेक्ट्रॉनिक उपकरणे प्रदर्शित केली जाऊ शकत नाहीत, म्हणून प्रतिवादीने अपीलकर्त्याने दाखल केलेला अर्ज रद्द करण्याची मागणी केली. 12 नोव्हेंबर 2021 रोजी उच्च न्यायालयाने प्रतिवादीच्या याचिकेला मान्यता देऊन कुटुंब न्यायालयाचा आदेश रद्द केला आणि उच्च न्यायालयाने संभाषण पत्नीच्या संमतीशिवाय गुप्तपणे रेकॉर्ड केले हे गोपनीयतेच्या अधिकाराचे उल्लंघन असल्याचे नमूद केले. या निर्णयाविरुद्ध अपीलकर्त्याने सर्वोच्च न्यायालयात सध्याचे अपील दाखल केले. आदरणीय न्यायाधीश महोदय, या केस संदर्भातील माझे 2 महत्त्वाचे मुद्दे आहेत ते आपल्यासमोर सादर करण्याची परवानगी मागत आहे. धन्यवाद महोदय. वैयक्तिक इलेक्ट्रॉनिक रेकॉर्डिंग संभाषण पुरावा म्हणून न्यायालयात ग्राह्य मानले जाऊ शकते का? आणि दुसरा माझा मुद्दा असा आहे की असे रेकॉर्डिंग संभाषण पुरावा म्हणून ग्राह्य मानले तर कलम 21चे उल्लंघन होईल का? आदरणीय न्यायाधीश महोदय, या केस संदर्भातील माझा पहिला युक्तिवाद आपल्यासमोर सादर करण्याची परवानगी मागत आहे. धन्यवाद महोदय. इलेक्ट्रॉनिक रेकॉर्डिंग संभाषण पुरावा म्हणून न्यायालयात ग्राह्य मानले जाऊ शकते का? आदरणीय न्यायाधीश महोदय, या प्रकरणातील तथ्ये अशी सांगतात की अपीलकर्त्याने दोघांमधील टेलिफोन संभाषणे वैयक्तिक मोबाईल फोनवर नोंदवली आणि ती मेमरी कार्ड, चिप्स आणि CD मध्ये सुरक्षित केली. भारतीय साक्ष अधिनियम 2023च्या कलम 2 उपकलम 1 खंड D नुसार इलेक्ट्रॉनिक रेकॉर्ड हे दस्तऐवज मानले जातात आणि पुरावा सादर करता येतात आणि मुख्यतः हे संभाषण फक्त अपीलकर्त्याच्या नियंत्रणाखाली केले गेले आणि यामध्ये कोणतीही तिसरी व्यक्ती सहभागी नव्हती. अपीलकर्त्याचा उद्देश फक्त हा होता की घटस्फोट याचिकेत सत्य शोधण्यासाठी पुरावा सादर करणे. याशिवाय भारतीय साक्ष अधिनियम 2023च्या कलम 63 यामध्ये इलेक्ट्रॉनिक पुराव्याची ग्राह्यता स्पष्ट करण्यात आली आहे. उपकरणाची योग्य माहिती इलेक्ट्रॉनिकमध्ये रेकॉर्डिंगमध्ये कोणत्याही प्रकारची छेडछाड झाली नाही अशी खात्री दिल्यास इलेक्ट्रॉनिक रेकॉर्ड थेट पुरावा म्हणून सादर करता येतात. त्यामुळे फक्त रेकॉर्डिंग हे वैयक्तिक आहे म्हणून नाकारण्याचा कोणताही कायदेशीर आधार नाही. तसेच कुटुंब न्यायालयाने 29 जानेवारी 2020 रोजी अपीलकर्त्याला या रेकॉर्डिंग पुरावा म्हणून सादर करण्याची परवानगी दिली. न्यायालयाने म्हटले की घटस्फोट प्रकरणात पक्षांमधील संभाषणे महत्त्वाची आहेत आणि अशा रेकॉर्डिंगसाठी कोणताही कायदेशीर प्रतिबंध नाही. याशिवाय केस फुटस्वामी वर्सेस युनियन ऑफ स्टेट 2017 या प्रकरणात सर्वोच्च न्यायालयाने असे ठरवले आहे की वैवाहिक विवादात इलेक्ट्रॉनिक रेकॉर्डिंग विश्वसनीय पुरावा म्हणून सादर करता येतो जेव्हा प्रत्यक्ष तिसऱ्या व्यक्तीचा साक्ष उपलब्ध नसते. म्हणून माननीय न्यायाधीश यांनी अपीलकर्त्याची वैयक्तिक इलेक्ट्रॉनिक रेकॉर्डिंग घटस्फोटाच्या याचिकेत पुरावा म्हणून पूर्णपणे ग्राह्य धरावी अशी मी विनंती करते.
Proceedings to the Honorable Bench. The Council seeks permission to collectively address the bench as your lordships and your ladyship. Much obliged. The Council is presenting on behalf of Respondent in the case of Vibhor Garg versus Neha. The Council seeks permission to proceed with the facts of the case. Much obliged. The Respondent and Petitioner, that is Vibhor Garg and Neha, were married in the year 2009 and disputes arose between the spouses due to Petitioner's conduct and mistrust. Petitioner secretly recorded the conversations of the communications between the husband and wife. And this was objected by the respondent, that is Neha, saying that it was a violation of her right to privacy. The High Court of Punjab and Haryana ruled in the favor of wife, and this is the appeal to the Supreme Court under Article 136 of the Constitution, that is special leave petition. Your lordships and your ladyships, the Council seeks permission to begin with the arguments for issue number 1. Much obliged. Issue number 1, whether secretly recorded conversations be permitted to be given as an evidence. Your lordships and your ladyship, it is humbly submitted before the honorable court that marriage in Indian jurisprudence is a sacrosanct institution and it is founded on mutual trust, confidence and emotional security, your lordships. And therefore the recordings that are procured through improper means is an intrusion on the right to privacy of the wife, that is the respondent, and should not be permitted to be used as an evidence in matrimonial proceedings. In addition to this, secret recordings are immorally obtained without the knowledge or consent of the other spouse, and hence it constitutes an intrusion into the most intimate sphere of private life,
and as conversations between spouses are among the most private forms of interaction, and therefore such conversations deserve protection under the law or by the law, Your Lordships and Your Leadership. It is also important to note that electronic evidences, unlike natural testimony, they speak through the hands of the person who have created this information or the person who is possessing this information. Thereby, they are susceptible to be manipulated. These evidences are susceptible to manipulation. Moreover, unilateral production of such evidences and selective presentation of such evidences before the court will not only violate the right of the other spouse, but will also set a dangerous precedent for the upcoming litigations, Your Lordship and Your Leadership. Moreover, therefore, it is contended that this particular presentation of evidences before the court also fails the test of reliability, because under section 63 of the Bharatiya Saksha Adhiniyam, it has been provided that a certificate has to be mandatorily issued by the authority maintaining such records, and Your Lordships and Your Leadership, such a certificate has not been issued in the present case by the petitioner. Moreover, it has to be considered that the legislative intent of the legislature while framing section 128 of the Bharatiya Saksha Adhiniyam is to ensure that spouses may communicate freely within marriage and without fear that their words will later be exposed in court proceedings. And therefore, permitting such evidence would defeat the legislative purpose and encourage spouses to use private conversations in future litigation as weapons, Your Lordships and Your Leadership. Additionally, permitting such an evidence would have serious implications on formulation of public policy, and it would have consequences as admitting such evidences would normalize surveillance within marriages and would also set a dangerous precedence.
Puran Mal versus Director of Inspection. This case, how it relates with your case?
Your Lordship, it has been taken as obiter dicta, which is a persuasive element, to persuade the court with respect to the case.
You are asking for admissibility of, non-admissibility of the conversation.
Indeed, yes.
Exception.
What about the exception? That is in section 128. That is the exception, no?
Indeed, Your Leadership. The exception provided under section 128, it says except if...
What are the two grounds for the exceptions?
Two
Two
grounds.
exceptions. What are those two exceptions?
Your Leadership, the communication in this particular case is not a direct communication. It is a record.
I am asking about the exceptions.
Only exception.
The counsel, please ignore his speech.
Book is with you right now?
My code number is A40 and I am appearing on behalf of the appellant. Counsel seek permission to proceed with facts. May I, ma'am? Much obliged. The appellant husband and the respondent wife were married on 2009 and one got
Proceed with the issues.
Counsel seek permission to proceed with issues. May I, ma'am? My issue number 1 is whether the High Court erred in law by excluding relevant electronic evidence solely on the basis that it was recorded without the consent of the respondent. My issue number 2 is whether the secretly recorded spousal conversation are admissible under Bharatiya Saksha Adhiniyam 2023. My issue number 3 is whether the High Court failed to correctly balance the respondent right to privacy under Article 21 of the Constitution of India with the appellant's right to fair trial. Counsel seek permission to proceed with the arguments. May I, ma'am? My lord, admissibility is governed by the relevant and reliability and not by the mode of collection. In the case Yusuful Nagris vs. State of Maharashtra, it was held that the conversation recorded secretly does not make it admissible, but the provided material should be relevant and authentic. In the further case, Arya Malkani vs. State of Maharashtra, the Honorable Court had given threefold test, which based on the relevance, identification of the voice and the proof against tampering. None of this contains the consent of the speaker. So no matter how the evidence is collected, whether unfairly or illegally, it does not affect the admissibility of the evidence. Also, Section 128 of the Bharatiya Saksha Adhiniyam, it is related to the marital privileges and does not talk about the mode of collection of the evidence. So, in the case State versus Navjot Sandhu, it was held that court must not close their eyes with the best available evidences. Counsel seek permission to proceed arguments for issue number 2.
काहीतरी सांगितलं.
International Covenant on Civil and
Is it binding on the part of the Indian legislation?
No, but we can use it as an supplementary under Article 14, 19 and 21. We cannot use it directly, but we can take a reference of it.
It's a directive, not mandatory.
Yes.
न्यायाधीश महोदया, मी कोड नंबर 14 आज आपल्यासमोर वादीची वकील ह्या नात्याने उभी आहे. माझ्या मूळ युक्तिवाद सुरुवात करण्यापूर्वी मी ह्या केस संदर्भातील घटनाक्रम थोडक्यात आपल्यासमोर मांडण्याची परवानगी मागत आहे. धन्यवाद महोदय. हां, आदरणीय न्यायाधीश महोदया, आदरणीय न्यायाधीश महोदय, ह्या केस संदर्भातील पहिला मुद्दा असा आहे की कुटुंब न्यायालयाने ऑडिओ रेकॉर्डिंग, ट्रान्स्क्रिप्ट आणि मेमरी कार्ड पुरावा म्हणून स्वीकारणे कायदेशीर व योग्य आहे का? मुद्दा नंबर 2, घटस्फोटाच्या प्रकरणात न्याय मिळवण्यासाठी गोपनीयतेचा अधिकार मर्यादित केला जाऊ शकतो का? मुद्दा नंबर 3, पत्नीने विरोध केल्यानंतरही अशा पुराव्यांचा वापर करणे नैसर्गिक न्यायाच्या तत्वांना बाधक ठरेल का? धन्यवाद महोदय. आदरणीय न्यायाधीश महोदया, माझ्या मूळ युक्तिवादात सुरू करण्यासाठी परवानगी मागत आहे. धन्यवाद महोदय. आदरणीय न्यायाधीश महोदया, ह्या केस संदर्भातील माझा पहिला युक्तिवाद असा आहे की कुटुंब न्यायालयाने ऑडिओ रेकॉर्डिंग, ट्रान्स्क्रिप्ट आणि मेमरी कार्ड पुरावा म्हणून स्वीकारणे योग्य आहे का? कुटुंब न्यायालयाने ऑडिओ रेकॉर्डिंग, ट्रान्स्क्रिप्ट आणि मेमरी कार्ड पुरावा म्हणून स्वीकारण्याचा आदेश देणे पूर्णपणे कायदेशीर, योग्य आणि न्यायाच्या हितासाठी आवश्यक आहे. कारण वैवाहिक वादामध्ये सत्य शोधणे हे न्यायालयाचे मुख्य उद्दिष्ट आहे आणि ह्या प्रकरणात हे इलेक्ट्रॉनिक पुरावे वादाचे प्रभावी निराकरण करण्यास मदत करतात. कौटुंबिक न्यायालय अधिनियम 1984चे कलम 14 नुसार कुटुंब न्यायालयात कोणताही अहवाल, विधान किंवा दस्तऐवज पुरावा म्हणून स्वीकारण्याचा अधिकार आहे जर तो वाद सोडवण्यासाठी उपयुक्त ठरत असेल. म्हणूनच कौटुंबिक न्यायालयात पुरावे स्वीकारण्याबाबत भारतीय पुरावा कायद्याचे नियम कठोरपणे लागू केले जात नाहीत. ह्याशिवाय भारतीय पुरावा कायदा 1872 अंतर्गत देखील इलेक्ट्रॉनिक पुरावे ग्राह्य आहेत. ऑडिओ रेकॉर्डिंग आणि ट्रान्स्क्रिप्ट हे वैवाहिक वादातील सत्य आणि परिस्थिती स्पष्ट करण्यासाठी आवश्यक पुरावे आहेत. कुटुंब न्यायालयाने योग्य अधिकार वापरून पुरावे स्वीकारले असताना उच्च न्यायालयाने केवळ गोपनीयतेच्या आधारावर तो आदेश रद्द केल्यास वादीला आपला दावा सिद्ध करण्याची संधी नाकारली जाऊ शकते आणि त्यामुळे वादीवर अन्याय होण्याची शक्यता निर्माण होते. कुटुंब न्यायालयाचा आदेश योग्य असून ऑडिओ रेकॉर्डिंग आणि ट्रान्स्क्रिप्ट पुरावा म्हणून स्वीकारले पाहिजेत, कारण न्यायालयाचे अंतिम उद्दिष्ट सत्य शोधणे हे न्याय प्रदान करणे हेच आहे. धन्यवाद महोदय. माझा आदरणीय न्यायाधीश महोदय, ह्या केस संदर्भातील माझा दुसरा युक्तिवाद असा आहे की घटस्फोटाच्या प्रकरणात न्याय मिळवण्यासाठी गोपनीयतेचा अधिकार मर्यादित केला जाऊ शकतो का? गोपनीयतेचा अधिकार हा संविधानिकदृष्ट्या महत्त्वाचा असला तरी तो पूर्णतः निरंकुश नाही. घटस्फोट सारख्या वैवाहिक वादामध्ये न्याय मिळवण्यासाठी आणि सत्य बाहेर आणण्यासाठी काही परिस्थितींमध्ये गोपनीयतेच्या अधिकारावर वाजवी मर्यादा घालता येतात. गोपनीयतेचा अधिकार हा भारतीय संविधानाच्या अनुच्छेद 21 अंतर्गत एक मूलभूत अधिकार आहे. जस्टिस के.एस. पुट्टास्वामी वर्सेस युनियन ऑफ इंडिया ह्या प्रकरणात सर्वोच्च न्यायालयाने गोपनीयतेचा अधिकार मान्य केला आहे, परंतु न्यायालयाने हे देखील स्पष्ट केले आहे की हा अधिकार पूर्णतः निरंकुश नाही, तसेच तो वाजवी मर्यादांच्या अधीन आहे. म्हणूनच वैवाहिक वादामध्ये सत्य बाहेर आणण्यासाठी आणि न्याय मिळवण्यासाठी गोपनीयतेच्या अधिकारावर काही प्रमाणात मर्यादा घालता येऊ शकते.
Honorable Lordship, I am code number R45, stand before the Honorable Court in the capacity of the Council on behalf of the Respondent. Before beginning of my submission, I seek the permission of the Honorable Court to present briefly the statement of facts.
Start with the issues.
Okay. The council seeks permission to start with the issues. Thank you, Your Honor. So the first issue which I raised was whether filing a divorce petition under the section 13 of Hindu Marriage Act 1955 by the appellant is legally sustainable and justified in the present case. The issue second which was raised, whether such secretly recorded evidences violates the fundamental right of privacy under the Article 21 of the Constitution of India. So the council seeks permission to proceed with argument. Thank you, Your Lordship. So with the filing the divorce petition under the section 13 of Hindu Marriage Act 1955 by the appellant is legally sustainable and justified in the present case. So Honorable Dias, instead of retrial of facts, I would directly undertake an inquiry to subject of correctness of the application under the section 13 of Hindu Marriage Act. Your Lordship, section 13 of Hindu Marriage Act applies for the divorce on the grounds of cruelty, adultery and desertion. But as the appellant stated that he was subject to the persistent mental cruelty by the wife, but he failed to provide the proofs of that cruelty, and also the statement of the appellant lacks confidential evidences. The cruelty is not only the mere pressure or the irritation caused in the marriage, but it should be grave, continuous and weighty enough. But the evidences submitted by the appellant for the cruelty were all electronic in nature, and lack of strong evidences like eyewitnesses and physical witnesses were not present. Thus, evidence has been trustworthy and real is challenged here. I would like to state the case of Samar Ghosh versus Jaya Ghosh of 2007. Herein the Supreme Court itself stated that cruelty must be of such a nature that the parties cannot reasonably be expected to live together. Petty quarrels and irritation and wear and tear in the marriage cannot amount for the cruelty. Also, it is a unilateral act caused by the appellant, and the recording of the conversations recorded lack the genuineness and completeness. Also, I would like to state that the roots of whether these evidences are admissible or not lies in whether the mental cruelty was done by the wife or not. Also, Your Honor, the counsel on behalf of the respondent clearly states that false and reckless allegations under the section 13 of Hindu Marriage Act harm the respondent's dignity and reputation and leads to the infringement of right to live with dignity under the Article 21 of the Constitution of India. Also, the appellant was not subject to the mental cruelty by the wife, and thus the evidences are inadmissible in nature. The counsel seeks permission to further state the issue. Thank you, Your Lordship. Second issue, whether such secretly recorded evidences violates the fundamental right of privacy under the Article 21 of the Constitution of India. The appellant herein submitted before the Honorable Court the transcripts of the conversations recorded along with the memory cards and chips of the mobile phones, leading to the violation of right to privacy, which is an intrinsic part of Article 21. That violated a recording a call or a video without the consent of the person violates the right to privacy, making the action very illegal. Also, I would like to state that in the Justice case Puttaswamy versus the Union of India, the Supreme Court held that secretly recording a spouse conversations without the consent and knowledge of any other spouse is a direct invasion of informational and decisional privacy, especially when done in a private and domestic setting. Also, Your Lordship, I respectfully submit that though right to privacy is not absolute under Article 21 of the Constitution of India,
however, case is related with Shobharani versus Madhukar Reddy. Page number 9.
In the case of Shobharani versus Madhukar Reddy, it is the Supreme Court has stated that cruelty is only admissible. Cruelty is only approved when it is serious and weighty. But in this condition, in the particular case of Vibhor Garga versus Neha, the cruelty done by wife is not very serious and not weighty. Petty quarrels done in this in the marriage do not constitute for the cruelty under Section 13 of in the Marriage Act.
How Puttaswamy case is related with your case?
This is Puttaswamy case versus the Union of India. Here they stated that secretly recording a spouse conversations in a married life is without the information and decisional privacy. It is unauthorized by the law. So, secretly recordings were done in the Vibhor Garg case versus Neha.
Right of privacy is violated or not?
Yes, right of privacy is violated under Article 21 of the
What about the
Constitution.
exception or basic section 128?
It states that if the
How many exceptions are there?
Is it with you?
Have you gone through the authority which is cited?
exceptions are not present, but it states that communication made by one spouse to the another during marriage is protected and cannot be disclosed in the court.
Have you gone through the section 128 of BSc?
Permission to present my case before the Honorable Court on behalf of the petitioner in case of the Viborg versus Neha. As the Honorable Court is well aware of the facts, may I proceed with the issues of the case? Much obliged. So there are three main issues which have been raised in this case, which are the first issue is whether High Court is correct in rejecting the audio recordings and transcriptions which the petitioner has presented in this divorce case, and second is whether recordings are admissible under the Indian Evidence Act properly, and third is whether the petitioner's right to fair trial has been violated due to the honorable decision of the Honorable High Court or not. Counsel seek permission to proceed with my arguments. So our first issue is whether High Court was correct in rejecting the evidence which was presented by the petitioner. Actually, this cruelty which was recorded on call records, this is a private act. There is no any witness available to for the petitioner to show his cruelty. And section 14 of the Family Courts Act clearly states that family courts generally have to accept all material evidences available. There is no need that evidence should be according to the admissible according to the Evidence Act. Because matrimonial disputes are generally taken place in private spaces, there is very few possibility that witnesses are available. So in this case, my petitioner has only recordings which is only reliable form of evidence through which he can show his cruelty. Otherwise, he won't be able to prove his case. It is impossible. It will become impossible for him to present his case if his evidence will get rejected. Present my much obliged. In the views of the facts stated, issues raised and arguments advanced, it is most respectfully prayed this Honorable Court may please to allow this appeal and set aside the decision and judgment of the High Court where they rejected the recordings as an evidence, and restore the order passed by the Family Court Bhatinda and permitting petitioner to rely on those electronic evidences, and also direct the said electronic evidence taken on record as an evidence to prove the cruelty of the respondent, because my petitioner wants strong ground to get divorce, and cruelty is only ground available to him to get divorce, and any other decision, order, judgment which court may fit deem, which will further justice and conscience and equality.
Under which provision you file a case?
Article 136 special due petition. I have filed this petition.
Under which circumstances this remedy is available to you?
This remedy is available when there is no appeal available to the petition to the person, and gross misjustice has been taken place, and along with it there is a public interest in this case, and justice needs to be given, and there is substantial question of
How public interest is involved?
Huh?
How public interest is involved?
His fundamental rights has been violated. If he won't be able to show
You are asking about right of privacy, na?
No.
Then how it relates with the
Public interest.
Because individual makes community, and right to interest is right of every individual person to stay in order in society.
How Zahira Habibullah Sheikh case is related with your case?
Here, court think that without hostile witnesses, without evidence of those hostile witnesses, court think that they cannot seek truth. So court allowed those hostile witnesses, means they allowed all the material evidences available in order to give justice to the murderer, victim of murder.
Council seeks permission to address the bench as your lordship and your ladyship. Much obliged. The council is presenting on behalf of petitioner in the case of Viborgar versus Neha. The council seeks permission to begin with the facts. Much obliged.
Proceed with the issues.
Okay. Issue number 1, where the secretly recorded conversations be permitted to be given as an evidence. It is humbly submitted before the Honorable Court that secretly recorded conversations are valid, reliable evidence and their admissibility cannot be disallowed just because they were recorded without the knowledge of the other spouse. Such recordings can be used as an effective means for proving cruelty under Section 13 of the Hindu Marriage Act 1955. It is further submitted that secrecy is necessary for recording relevant evidentiary material. In the case of Deepthi Kumar versus Kunal Jalka, please refer page number 1, flag number 1. The court has held that recorded conversations between spouses recognize matrimonial disputes involving the conduct that occurs in private and which cannot be proved through traditional forms of evidence. Moreover, in the case of Preeti Jain versus Kunal Jain, the court has accepted spousal communication as evidence in divorce proceedings, acknowledging the cruelty is often reflected through words spoken behind the closed doors. Your lordship and your ladyship, it is further submitted that secrecy cannot disallow admissibility and cigarette recordings qualify as relevant evidence under the Bharatiya Saksha Adhiniyam or the Evidence Act. Your lordship and your ladyship, electronic recordings are recognized as documentary evidence under the section 2 of the Bharatiya Saksha Adhiniyam and are admissible when supported by the requirements under section 63 of Bharatiya Saksha Adhiniyam. Additionally, in the case of Esaki Amal, please refer flag number 8, it has been held that recorded conversations are admissible when they have relevance to the dispute and assist the court in determining the truth. Your lordship and your ladyship, the recorded conversation meets the threefold admissibility test as held in R.M. Malkani versus State of Maharashtra, wherein relevance, confirmed identity and accuracy is proved, hence it is admissible. It is further submitted before the Honorable Court that if secretly recorded evidence is excluded solely, be it was obtained privately, the court would be deprived of the most fruitful material, thereby defeating the very purpose of justice. Moreover, exclusion of such recordings would encourage concealment of cruelty and allow wrongdoing to go unproved. If your lordship and your ladyship are satisfied with the arguments for issue number 1, the council seeks permission to begin the arguments for issue number 2. Much obliged. Issue number 2, where in light of Evidence Act and the Family Court Act, a conversation between spouses can be permitted to be given as evidence in a proceeding for divorce. It is submitted before the Honorable Court that combined reading of Section 128 of Bharatiya Saksha Adhiniyam and Section 14 of the Family Court Act, please refer flag number 3. Wherefore, in the light of issues raised, arguments advanced, reasons given, and the authorities seated, it is most humbly prayed before this Honorable Court that it may be pleased to hold that secretly recorded conversations between the spouses are admissible, declare that Section 122 of Evidence Act does not bar such evidence, reject the plea of exclusion solely on the ground of privacy, as privacy is not absolute and cannot surpass truth in criminal disputes, pass any other relief that this court may be pleased to grant in the interest of justice, equity and conscience. For this act of kindness, the councils on behalf of the petitioner as in duty bound shall forever pray. It was an honor to argue before this court.
Under which provision you applied, you came before this court? Under which provision you came before this court?
According to section 128.
According to section
128.
128.
Section 128 said, protects private talks between the spouses, but it gives exception for suits between married persons.
Did I get the question? You have did appeal here only in the Supreme Court, or you came before this court under special leave?
No, I came as special leave petition.
Why?
Because the High Court decision, the High Court judgment was, because we were not satisfied with the High Court judgment.
That is, appeal provision is available with you, right?
Yes.
then appeal provision is available with you. Why you have taken the relief under Article 136?
Counsel pleads ignorance.
मी कोड नंबर A41 आज आपल्यासमोर अपीलकर्त्याची वकील या नात्याने उभी आहे. मी या केस संदर्भातील मूळ युक्तिवादास सुरुवात करण्यापूर्वी आपल्याला विनंती करते की या केस संदर्भातील घटनाक्रम थोडक्यात सांगा.
Proceed with the issues.
आदरणीय न्यायाधीश महोदया, मी या केस संदर्भातील मुद्दे आपल्यासमोर मांडण्याची परवानगी मागते. धन्यवाद महोदया. मुद्दा क्रमांक 1. अपीलकर्त्याला फोनवर रेकॉर्ड केलेल्या स्वरूपात पक्षांमधील संवादाचा समावेश असलेले पुरावे सिद्ध करण्याची परवानगी नाकारणे योग्य आहे का? मुद्दा क्रमांक 2. अशा प्रकारे रेकॉर्ड केलेले पुरावे केवळ पती पत्नीपैकी एकाच्या गोपनीयतेचे उल्लंघन होत आहे या कारणास्तव नाकारले पाहिजे का? आदरणीय न्यायाधीश महोदया, मी या केस संदर्भातील माझा पहिला युक्तिवाद आपल्यासमोर सादर करण्याची परवानगी मागते. धन्यवाद महोदया. मुद्दा क्रमांक 1 या संदर्भातील माझा पहिला युक्तिवाद आहे. अनेकदा पुराव्यांच्या अभावी कोर्टाला किंवा न्यायालयाला न्याय देणे अवघड जाते. पण आपण 21व्या शतकात जगत असताना तंत्रज्ञानाचा वापर करून, इलेक्ट्रॉनिक उपकरणांचा वापर करून रेकॉर्डिंग केलेले ऑडिओ किंवा व्हिडिओ असे पुरावे सादर करून न्याय मागणे पक्षकारांसाठी सोपे झाले आहे. माननीय कुटुंब न्यायालयाने कुटुंब न्यायालय कायदा 1984च्या कलम 14 व कलम 20 यांच्या आधारे अशा प्रकारे रेकॉर्ड केलेले पुरावे सादर करण्यावर कोणताही कायदेशीर निर्बंध नाही असे स्पष्ट केले आहे. त्याचप्रमाणे भारतीय साक्ष अधिनियमच्या कलम 128 जो पूर्वीचा भारतीय पुरावा कायदा 1872च्या कलम 122शी संबंधित आहे, त्यामध्ये दोन भाग आहेत. एक भाग परवानगीचा आणि एक सक्तीचा. परवानगीच्या भागामध्ये 2 अपवाद आहेत. जेव्हा पती पत्नी एकमेकांविरुद्ध खटला चालवतात तेव्हा हा कलम लागू होत नाही. त्याचप्रमाणे जेव्हा एक जोडीदार दुसऱ्याविरुद्ध केलेल्या गुन्ह्यासाठी खटला चालवतो त्यावेळेला सुद्धा हा कलम लागू होत नाही. जेव्हा कलम 128चा उद्देश हा पती पत्नींमधील विश्वास जपणे हा आहे, परंतु जेव्हा पती पत्नी स्वतः एकमेकांविरुद्ध खटला चालवतात तेव्हा हा कलम लागू होत नाही. दीपाली विरुद्ध प्रवीण 2023चे प्रकरण पुष्ट क्रमांक 8 रेफर करण्याची मी विनंती करते. दीपाली विरुद्ध प्रवीण 2023च्या प्रकरणात कर्नाटक उच्च न्यायालयाच्या धारवाड खंडपीठाने भारतीय साक्ष अधिनियमच्या कलम 128 व 28च्या अपवादावर प्रकाश टाकत घटस्फोटाच्या याचिकेत किंवा घटस्फोटाच्या कार्यवाहीत व्हिडिओ रेकॉर्डिंग आणि व्हॉट्सॲप संदेश असलेली सीडी पतीने रेकॉर्डवर ठेवण्याची परवानगी दिली होती. त्याचप्रमाणे नरेंद्रनाथ मुजुमदार विरुद्ध राज्य 1951च्या प्रकरणात कोलकाता उच्च न्यायालयाने सुद्धा व्हिडिओ रेकॉर्डिंग किंवा ऑडिओ रेकॉर्डिंग घटस्फोट वैवाहिक वादामध्ये सादर करण्याची परवानगी दिली जाऊ शकते असे स्पष्ट केले होते. धन्यवाद महोदय. आदरणीय न्यायाधीश महोदय, मी या केस संदर्भातील विशद केलेला माझा युक्तिवाद आणि त्या संदर्भातील निवाडे विचारात घेऊन मी आदरणीय न्यायाधीशांना विनंती करते की त्यांनी अपीलकर्त्याला फोनवर रेकॉर्ड केलेल्या संभाषणाचे ट्रान्स्क्रिप्ट सादर करण्याची परवानगी द्यावी. भारतीय साक्ष अधिनियम 2023च्या कलम 128चा अपवाद लक्षात घेऊन सादर केलेले पुरावे स्वीकारावेत. पुराव्यांची सत्यता तपासून हिंदू विवाह कायदा 1955च्या कलम 13च्या अंतर्गत क्रूरतेच्या आधारे घटस्फोट मंजूर करावा. न्याय, समता आणि सत्सद विवेकबुद्धी या गोष्टी विचारात घेऊन कोणताही आदेश किंवा निर्णय पारित करण्यात यावा, ज्यासाठी अपीलकर्ता व प्रतिवादी बांधील राहतील ही नम्र विनंती.
या कोर्टात कोणत्या तरतुदी खाली आला?
भारतीय राज्यघटनेच्या कलम 136.
कलम
136.
परिशिष्ट 136च का?
कारण जेव्हा भारतातील इतर कोणत्याही न्यायालयाने किंवा न्यायाधिकरणाने दिलेला निर्णय हा जेव्हा इनजस्टिसेबल वाटतो आपल्याला तेव्हा आपण या तरतुदीनुसार
काही आहे तुमच्याकडे दाखवा.
To the honorable bench, if it may please, the council seeks permission. If it may please, the council seeks permission to address the bench.
R67.
Yes.
Proceed with the issues.
Honorable bench, my code number is R67. The council is appearing before the honorable court in a matter of Viborgar versus Neha on behalf of respondent in response to the petition filed under the Article 136 of the Indian Constitution. Honorable Lordships, with your kind permission, council seeks to place on a record the memorial and brief extracts of the judgments relied upon.
Memorial.
Much obliged. If the bench is well versed with the facts of the case, the counsel for respondent would like to proceed with the issues.
Proceed.
Much obliged. Honorable bench, this case raises a narrow but profound question: can a secret surveillance inside a marriage be legitimized in the name of matrimonial justice? I respectfully submit it cannot and it must not. With your lordship's leave, I shall address the three consolidated issues. Much obliged. Issue number first, whether the High Court was justified in setting aside the family court's order or permitting the CD containing secretly recorded spousal conversations. Issue second, whether the surreptitious recording of spousal conversations violates Article 21 warranting exclusion of such evidence. And issue number third is whether the secretly recorded marital conversations are admissible in the matrimonial proceedings having regard to the Bharatiya Sakshi Adhiniyam and Family Courts Act and settled evidentiary principles.
Can you put before us the actual chronology of your facts? What the cases happened? For
Your
what
Lordship,
purpose you are coming over here?
yes, these are the consolidated issues. So first is about the High Court's judgment, which was High Court of Punjab and Haryana, who set aside the Family Court of Bhatinda's judgment. And issue number second is about the invasion of violation of Article 21.
What the actual cases happened? What are
Facts of the case.
facts of the case in chronology aspects?
Your Lordships, this is a matter between the husband and wife, and this is about the surveillance in a marriage. Husband has recorded call recordings of wife secretly without her consent, and now he is appealing to the court to make them admissible as the evidence, which clearly violates the section 128 of Bharatiya Sakshi Adhiniyam, and it cannot be plead with the protection of section 14 and section 20 of Family Courts Act.
What is the decision of lower court?
Of High Court or Bhatinda's Court? High Court has given its decision in favor of the wife, who is Neha, that the surveillance in a marriage is violating her right to privacy, dignity and integrity.
Now you are asking for?
Pardon?
Now you are asking for which remedy?
Now I am asking for the appeal which has been filed by the husband should be dismissed and prayer. Much obliged.
Just turn page number 2 of your memorial. Point number 1.2. Read it and
Section 14 of the Family Courts Act does not override the constitutional guarantees of Bharatiya Sakshi Adhiniyam.
proceed.
Should I read the whole? Yes. The appellant's reliance on the Section 14 of the Family Courts Act 1948 is a misconcept.
Means what?
Means what?
Have you gone through the section 14 of the Family Court Act?
Yes, ma'am. Counsel would like to answer this with the reference to me.
Is it with you right now?
It's not in a proper format. I have written it down.
Yes.
So, Section 14 of the Family Court Act allows the courts to consider the evidence, which is the electronic record, regardless of its admissibility in the Indian Evidence Act, which is now Bharatiya Sakshi Adhiniyam.
You are asking for right of privacy is violated or not?
Yes, it is violated.
It is violated.
Yes.
Then how it's related with section 14?
I am pleading
Is
before.
it not a contradictory statement?
I would like to explain.
Try your best.
So, your lordships, section 14 gives a relaxation in the admissibility of evidence in a family code.
Get it?
Yes.
Okay. Stick up with that statement. Proceed.
Discretion with the Family Court.
Counsel was pleading that the Article 20 is violated because the husband is presenting the evidence which should be in which are violative of wife's privacy, as all the conversations were recorded without her consent and without her knowledge.
Section 14 is allowed to give the admissibility to such evidences?
Yes.
Yes or no?
Yes.
Yes.
But it cannot override the Article 21 of the Constitution.
How?
May I explain? So, we can see. Council would like to refer the brief first.
This is confined with right of privacy only?
No, sir.
No. Which is another?
Along with the right of privacy, it focuses on the core issue, which is about the Evidence Act, like evidentiary admissibility of the evidence in a matrimonial disputes.
Second. Third?
May I refer the brief?
No.
So first,
no, you refer the brief. Please go through it. Only the thing is that 2 questions you have been stated so far. What about third? Is it related with maintenance something?
maintenance of?
Maintenance?
The first issue can be arise on the maintainability of the suit under the Article 136 of the Indian Constitution. Because the Article 136 of the Indian Constitution is about the special leave petitions, where the miscarriage of justice or what we can say, where there is miscarriage of justice or question of a core legislative or core statutory provisions, then 136 is imposed. So in this current case, the High Court first put a stay on order of a judgment of a Patinda's court.
With the facts of the case, may I? Much obliged. The facts of the case are as follows. The appellant Vibhorgar and the respondent Neha were married according to Hindu rites and ceremonies. After the marriage, serious matrimonial disputes arose between the parties, leading to mental discord and breakdown of the marital relationship. Owing to continuous mental cruelty allegedly inflicted by the respondent, the appellant filed a petition for divorce under Section 13 of the Hindu Marriage Act 1955 before the Honorable District Court at Bhatinda. During the pendency of the divorce proceedings, the appellant produced certain voice recordings along with their transcripts as electronic evidence to substantiate his allegation of mental cruelty. The said recordings were relevant to the issues involved in matrimonial dispute. The respondent raised an objection to the admissibility of the said electronic evidence on the ground that voice recordings had been made without her consent and therefore amounted to an invasion of her fundamental right to privacy under Article 21 of the Constitution of India, as well as the violation of spousal privilege. The Honorable Court, while considering the objection raised by the respondent, declined to take the said voice recordings and transcripts into consideration, primarily on the ground that they were obtained without the consent of the respondent. Aggrieved by the exclusion of relevant electronic evidence and resulting prejudice caused to his case, the appellant preferred an appeal contending that such evidence is legally admissible and necessary for just adjudication of matrimonial disputes. The matter has now been brought before the Honorable Supreme Court of India, raising important questions of law concerning the admissibility of electronic evidence, the scope of the right to privacy, and the balance between privacy and right to fair trial in matrimonial proceedings. The Council seeks permission to proceed with the issues raised. May I? Much obliged. So the issues of the cases are whether the voice recordings and its transcripts produced by appellant as evidence without the consent of the respondent are admissible in matrimonial dispute. Issue number 2 is whether production of such voice recordings amount to invasion of respondent's private right to privacy under Article 21 of the Indian Constitution. Issue number 3 is whether exclusion of such evidence would result in denial of justice to the appellant in proving cruelty as the ground for divorce under Section 13, Clause 1, Subclause IA of the Hindu Marriage Act 1955.
122 of Indian Marriage Act.
Section 128.
Yes, sir. 128.
New Act.
Or old
Which is old Act and which is New Act?
The Section 122 BSc 2023. The Council seeks to apologize on.
Yes, sir.
Take your time.
So should I proceed with the issue number 3?
Which section is favored to you?
The section I am referring to is section 122 and 128 of BSc 2023.
122 and?
Sorry, sir?
122 and?
122 and 128 of BSc Bharati Sakshi Adhiniyam 2023.
Proceed.
Much obliged, sir. Whether issue number 3 is whether exclusion of such evidence would result in denial of justice to the appellant in proving cruelty as a ground for divorce under Section 13, Clause 1, Subclause IA of Hindu Marriage Act 1955.
Section 13.
13, Clause 1, Subclause IA of the Hindu Marriage Act, which is for cruelty. Cruelty is often...
What is Section 14?
Section 14 of the
Family Act.
Honorable Lordship, I would like to refer to the records.
Here is on behalf of appellant in the case of Vibor Gaur versus Neha. The council seeks permission to proceed with the issues raised if the court is well aware about the facts of the case. Much obliged. First issue raised here is whether the Punjab and Haryana High Court was correct in setting aside the family court's order permitting the husband to produce the recorded conversations as evidence. The issue number 2 raised here is whether secretly recorded telephonic conversations between spouses are admissible as evidence in matrimonial proceedings. The issue 3 raised here is whether admitting secretly recorded spousal conversations constitute a breach of right to privacy under Article 21. The council now seeks permission to proceed with the arguments advanced.
Under which jurisdiction you came before this court?
Under Article 136 of the Constitution of India.
136 of?
Constitution of India.
Under which circumstances this remedy is available with you?
Actually, the petitioner had failed in the High Court, so he is not. It has been injustice to the petitioner. So the petitioner has again filed it in the Supreme Court so that he gets justice.
Why didn't you catch the appeal provision? Why didn't you take the benefit of appeal provision? Why you are confined with Article 136? Though that particular remedy is available with you? I don't know.
Sorry, the applicant.
Can you cite the grounds for Article 136 once again?
It is that the it has been injustice to.
Is it with you?
No.
दिले ते दिले त्याने सबमिट केलं आहे ना कागद आहे तुमच्याकडे whichever you have submitted along with your memorial. Read it, nothing.
Notwithstanding anything in this chapter, the Supreme Court may in its discretion grant special leave to appeal from any judgment, decree, determination, sentence or order in cause or matter passed or made by any court or tribunal in the territory of India.
You have submitted, but you don't go through it now. You have submitted so far.
I have not mentioned it in the memorial.
You have not mentioned so far in the memorial. But you have submitted to the court.
Nothing in the clause 1 shall apply to any judgment, determination, sender or order passed or made by any court or tribunal constituted by or under any law relating to armed force. No appeal shall lie to the Supreme Court from any judgment, determination, sentence or order passed or made by the court or tribunal constituted by or under any law relating to the armed force.
What is the judgment of lower court? What is the judgment of lower court?
Lower court has dismissed it that electronic evidence is not admissible.
Proceed.
The council seeks permission to proceed with the arguments advanced. Much obliged. The first issue raised here is whether the Punjab and Haryana High Court was correct in setting aside the family court's order permitting the husband to produce the recorded conversation as evidence. I would like to start with the Latin maxim which states that omnia probentia res petitioner, which states that all evidence is admissible unless expressly excluded by the law. Honorable Lordship and Ladyship, the Family Court acted squarely within its statutory discretion under the Family Courts Act 1984. It is a settled principle of evidence that all relevant evidence is admissible unless there exists an express statutory bar. The recorded conversations directly pertain to allegations of matrimonial cruelty and the conduct of the parties under Section 5 and 7 of the Evidence Act, thereby clearly satisfying the test of relevance. Honorable Lordship and Ladyship, in case of R.M. McCartney versus State of Maharashtra and Yusuf Ismail Nagri versus State of Maharashtra, this Honorable Court conclusively held that tape-recorded conversations are admissible even if recorded without consent, provided that there is relevance and authenticity. Family Court, as the court of the first instance, correctly exercised its discretion by admitting the recordings after due verification. The High Court, however, overstepped its discretion by excluding the evidence at the threshold, thereby substituting its own discretion for that of the trial court.
Honorable Lordship and Ladyship, by excluding relevant evidence at the preliminary stage, the High Court caused manifest prejudice to the petitioner and undermines the fairness of trial process. Such exclusion negates the family court's role and imposes an unwarranted judicial impediment, contrary to the settled principle that judicial acts must further not frustrate justice.
आदरणीय न्यायाधीश महोदय, मी कोड नंबर A29 आज वादीची वकील या नात्याने आपल्या समोर उभी आहे. या प्रकरणातील घटनाक्रम आपल्या समोर थोडक्यात मांडण्याची परवानगी मागत आहे. वादी आणि
आपण कोणत्या अधिकार क्षेत्रात या न्यायालयात उभे आहात?
कलम 136.
136.
हां.
कोणत्या परिस्थितीमध्ये कलम परिशिष्ट 136 लागतंय?
जर भारतातील कुठल्याही न्यायालयाच्या विरोधात जर आपल्याला अपील करायचं असेल सर्वोच्च न्यायालयात तर कलम 136 लागू होते.
अशा पद्धतीचं काही डॉक्युमेंट तुमच्याकडे आहेत का?
हो, अधिकार क्षेत्राचे विधानमध्ये हे नमूद केले.
ते लिहिलंय, पुस्तक वगैरे काय आहे ते तुम्ही लिहिलं ते फायनल आहे का? आमच्याकडे काहीतरी पाहिजे ना.
हो.
ते काय असू शकतं आम्हाला दाखवायला?
Any provision in that respect?
बरोबर ना, त्या संबंधित असणाऱ्या तरतुदी ह्या तुमच्या याच्यानुसार बघणार आम्ही की आम्हाला दाखवायला तुमच्याकडे काय आहे?
नाही.
अपील आणि अपील प्रोव्हिजन आणि 136 मध्ये काय फरक आहे सांगता येईल का?
घटनाक्रम मांडण्याची मला परवानगी द्यावी. वादी आणि प्रतिवादी यांचा विवाह कायदेशीररित्या झाला, परंतु काही काळाने प्रतिवादीकडून वादीला सतत अपमानास्पद आणि क्रूर वागणूक दिली जात होती. त्यामुळे सत्य सिद्ध करण्यासाठी वादीने काही फोन कॉल रेकॉर्ड्स केले. यावर प्रतिवादीने असा युक्तिवाद केला की सदर रेकॉर्डिंग हे गोपनीयतेच्या अधिकाराचे उल्लंघन असून भारतीय साक्ष अधिनियम कलम 128 अंतर्गत ते ग्राह्य धरता येणार नाही. उच्च न्यायालयाने हा युक्तिवाद मान्य केला आणि पुरावा अमान्य ठरवला. त्यामुळे वादीच्या निष्पक्ष सुनावणीचा अधिकार बाधित झाला असून सदर अपील दाखल करण्यात आले आहे. धन्यवाद महोदय. माझे मूळ मुद्दे आणि युक्तिवाद मांडण्याची मला न्यायालयाने परवानगी द्यावी. धन्यवाद महोदय. माझा पहिला मुद्दा आहे की सदर अपील माननीय सर्वोच्च न्यायालयात ग्राह्य आहे काय? यावर असा युक्तिवाद आहे की सदर अपील माननीय सर्वोच्च न्यायालयात ग्राह्य आहे कारण या प्रकरणात घटनात्मक प्रश्न उपस्थित होतो. उच्च न्यायालयाने पुरावा अमान्य ठरून वादीच्या निष्पक्ष सुनावणीच्या अधिकारावर परिणाम केला आहे आणि त्यामुळे सर्वोच्च न्यायालयाने यात हस्तक्षेप करणे आवश्यक आहे. माझा दुसरा मुद्दा आहे की पती पत्नीमधील गुप्तपणे रेकॉर्ड केलेले फोन कॉल्स पुरावा म्हणून स्वीकारता येतील काय? माननीय महोदय, बेकायदेशीररित्या मिळवलेला पुरावा देखील जर तो सुसंगत असेल तर तो स्वीकारला जाऊ शकतो आणि मुळात भारतीय कायदा सत्य काय आहे यावर भर देते, ते कसे मिळवले आहे यावर नाही. आर्य मलकानी विरुद्ध महाराष्ट्र राज्य 1973 या प्रकरणात सर्वोच्च न्यायालयाने स्पष्ट केले आहे की गुप्तपणे केलेले संभाषणाचे रेकॉर्डिंग जर सत्य शोधण्यासाठी आवश्यक असेल तर ते पुरावा म्हणून स्वीकारले जाऊ शकते. या प्रकरणात न्यायालयाने कॉल रेकॉर्डिंगची ग्राह्यता निश्चित करण्यासाठी आवश्यक त्या चाचण्या पूर्ण झाल्यास हा पुरावा स्वीकारला जाऊ शकतो असेही स्पष्ट केले आहे. माझा तिसरा मुद्दा आहे की भारतीय साक्ष अधिनियम 2023 कलम 128 सदर प्रकरणात लागू होतंय काय? माननीय महोदय, कलम 128 चा उद्देश हा विवाह संस्था वाचवणे आणि तृतीय व्यक्तीच्या हस्तक्षेपापासून पती पत्नीमधील संवादाचे संरक्षण करणे हा आहे. परंतु त्याला काही अपवाद आहे. जसे जर संवाद दोघांच्या संमतीने उघड केला असेल किंवा तो विवाहाआधी किंवा घटस्फोटानंतर झाला असेल तर हे संरक्षण लागू होत नाही. तसेच जर खटला पती पत्नीमध्ये चालू असेल तरी सुद्धा हे संरक्षण लागू होत नाही आणि ह्या अपवादामुळे कलम 128 सदर प्रकरणात लागू होत नाही. आणि जर पती पत्नीच्या संभाषणातून मानसिक क्रूरता किंवा अत्याचार या गोष्टी स्पष्ट होत असतील तर न्यायालयाने या बाबतीत व्यापक दृष्टिकोन स्वीकारणे आवश्यक आहे. अन्यथा कलम 128 चा वापर अन्याय लपवण्यासाठी देखील होऊ शकतो. माझा चौथा मुद्दा आहे की गोपनीयतेचा अधिकार हा निष्पक्ष सुनावणीपेक्षा श्रेष्ठ आहे काय?
Is on behalf of respondent in the case of Viborkar versus Neha. The council seeks permission to proceed with the issues. May I? Issue 1. Whether secretly recorded telephonic conversations between spouse can be admitted in evidence, tape recorded evidence is admissible only upon strict safeguards. My lord, tape recorded evidence is not automatically admissible. In R.M. Malkani vs. State of Maharashtra, this honorable court permitted tape recordings only after laying down strict conditions, namely that the conversation must be relevant, the voice must be properly identified, the recording must be proved to be accurate and untampered. The custody of the device must be clearly established.
Go through page number 6. Read it and explain it.
The respondent humbly submits that this honorable court has jurisdiction to enter present appeal under Article 136 of the Constitution of India. The matter arises out of judgment of the Honorable Punjab and High Court in a revision petition against the interlocutory order passed by the family court.
You have no question for jurisdiction. You have no question or objection for jurisdiction.
So the fundamental rights are not absolute.
Whether you have any kind of objection on 136 or not.
You are raising any objection
Yes.
for maintainability of this appeal before the Honorable Supreme Court?
Have you get the question?
Yes, sir. I have objections. The fundamental rights are not absolute, but in these conditions, in this case, the fundamental right is not violated.
Let it be that. We are not concerned about the violation of right or not. We are just confined our say on the question Article 136. Is it maintainable or not?
Yes, sir, it is correct.
You have no any kind of objection? No. That's why I am asking. No? Proceed.
Tape recorded evidence is inherently weak evidence and can be relied upon only if the properly proved and corroborated. Thus, recording cannot be mechanically admitted, especially at threshold, without proof, certification and forensic scrutiny. Matrimonial disputes demand higher, not low scrutiny. In matrimonial disputes, court must act with higher sensitivity. Allowing spouse to secretly record each other would convert marriage into a zone of surveillance. Private disagreements become permanent evidence and reconciliations become impossible.
Conversation between spouses can be admitted.
So, secretly conversation between spouses can't be admitted, as that conversation are in
Under which
between.
provision? Under which provision?
Under 128, section 128 of B.
Have you gone through the provision? Read it.
No person who is or has been married shall be compelled to disclose any communication made to him during marriage by his spouse, nor shall be permitted to disclose such communication unless the person who made it or their representative in interest contest, except in suits between married persons or proceedings where one spouse is for a crime against the other.
Your client's right of privacy is violated or not?
Right of privacy is violated.
Violated.
That's all with the issue 1. Your Lordship, the Council now seeks permission to proceed with the issue 2. Much obliged. Whether the right to privacy under Article 21 bars such recordings. Privacy is a fundamental right. In Justice K. S. Puttoswamy vs. Union of India, the right to privacy is constitutional protected right under Article 21, rooted in dignity, autonomy and personal liberty. Privacy includes control over personal communications and freedom from unauthorized surveillance. Marriage does not extinguish individuality. A spouse does not surrender constitutional right at the altar of matrimony.
Go through page number 10. R.M. Malkani case.
In R.M. Malkani vs. State of Maharashtra, this honorable court laid that the tape recorded conversation may be admitted only when the conversation is relevant, the voice is properly identified, the recording is accurate and free from tampering. The device was in proper custody.
Your case is related with this case?
Sir, the appellant has not submitted the proper evidence in the family court. The chief executive officer has not.
This case is favored to you or it's against you?
This case is.
Are you relying on this citation, case law, or not?
You have wrote it down only here only, na? Okay. Is it relates with your case?
Yes.
How?
Sir, they have given the evidence which is not at all, which is not justified in the family court. The chief executive officer has not gone through.
Read it once.
Lordship, my code number is A15. I appear on behalf of the petitioner. As your lordships are well versed with the facts of the case, counsel seeks permission to humbly submit the legal issues involved in the present case. Much obliged. Your lordship, there are mainly 3 issues involved in the present case. Firstly, whether special leave petition under Article 136 of the Indian Constitution is maintainable or not. The second issue is whether
under which jurisdiction you came before this court?
Under special leave petition under Article 136. Because your lordship, my humble submission is the decision of the Honorable High Court is under the civil revision petition, and there is no statutory provision available for the appeal as such. So this Article 136 special leave petition is the efficacious remedy available for the appeal.
Can you read the provision?
Yes, your lordship.
Please.
Article 136 of the Indian Constitution, special leave to appeal by the Supreme Court. Notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from the any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in the territory of India.
Proceed.
Much obliged. Your lordship, the second issue is whether right to privacy is bars the reception and consideration of the covertly recorded conversation between the married persons in the divorce proceedings. Third issue is whether such electronic evidence is admissible under the Family Court Act 1984 and Bharatiya Saksh Adhiniyam 2023. Counsel seeks permission to humbly submit the arguments. Much obliged. Considering the first issue, whether special leave petition under Article 136 is maintainable or not. Your lordship, in this special leave petition, there are substantial question of law is involved, such as the admissibility of the electronic evidence in the matrimonial proceedings. Secondly, the scope of section 14 of the Family Court Act. Then interpretation of section 128 of the Bharatiya Saksh Adhiniyam, and also the constitutional balance between the right to privacy and right of fair trial. Also, secondly, there are different judicial approaches by different honorable high courts. Few honorable high courts allowed the such electronic evidence. However, few honorable high courts disallowed it. Considering all these parameters, it is this honorable Supreme Court's intervention is necessary to give uniformity and authoritative settlement of law. Coming to the second issue, whether the right to privacy bars the admissibility, reception and consideration of the covertly recorded conversation. Your lordship, normally whatever marital dispute happens, it happens in the matrimonial home in the private settings where no third party witness is available. So considering in this technological era, the electronic evidence to be a part of the adjudication of the matter is imperative. No doubt the right to privacy is a fundamental right. However, it is not an absolute one. This position is held by this honorable court in the case or landmark judgment of K.S. Puttaswamy versus Union of India. On the other hand, right to fair trial is also a fundamental right, and to produce the relevant evidence before the honorable court for the adjudication of the matter is also a part of it. Your lordship, the constitutional balance between the right to privacy and right to a fair trial is it needs to be assessed by the proportionality test. prayed that to set aside the impute order of Honorable High Court, then it is humbly prayed that to restore the interlocutory order of the family court and to grant the special leave petition. Much obliged, Your Lordship. Much obliged.
We have completed with today's proceedings of Moot Court competition. Honorable Ladyship and Lordship, we have completed with today's proceedings of Moot Court competition. I request Principal Sir to please talk few words.
टोटल नाही आज 14 होते. आज 14 टोटल 174.
So it has been an amazing experience that almost close to 200 students participated in this particular event. From 200 students, 14 have qualified for this particular session. And I had a privilege of listening to a few of you. Presentations were exceptional. Preparation wise, as you grow up and as you scale up to the next class, preparations will be for sure sharper. Mooting is not an easy task. In order to be a mooter, you require a lot of skills. Of course, language is one of them, but having the full control over the facts and the appreciation of law, these are the two essential things in order to be a good mooter. And as far as the presentations which I heard personally, I found that few of the students performed exceptionally well when Madam was questioning them, especially about that new section 122 exceptions, right? 2 exceptions. I tell you, this is a secret hint that whenever you participate in any of the Moot Court competitions, the first thing you should carry is the Dare Act. Without the Dare Act, never participate in any of the Moot Court competitions, because essentially mooting is all about the appreciation of provisions, and therefore without having a Dare Act, you are not to argue. ठीक आहे, कॉलेज लेवलचा Moot Court कॉम्पिटिशन आहे, आपण इथपर्यंत सुरू त्यामुळे ठीक आहे, काय हरकत नाही. परंतु ज्या वेळेला आपण कॉलेजला रिप्रेझेंट करत असतो बाहेरच्या कॉलेजेसमध्ये किंवा युनिव्हर्सिटीजमध्ये, तर त्यावेळेला ते गरजेचं आहे की तुम्ही ज्या ज्या प्रोव्हिजन्स हायलाईट करणार आहात त्या सगळ्या प्रोव्हिजन्सचे ॲक्च्युअल Dare Acts तुमच्याकडे असणं गरजेचं आहे. कुठल्या तरी न्यूज आयटमचा स्क्रीनशॉट घेऊन किंवा अनअथॉराइज्ड लॉ रिपोर्टर्सची जजमेंट घेऊन तुम्हाला वोटिंग करता येणार नाही. केला तर जज म्हणून मी तुम्हाला काही बोलणार नाही, कारण जजेसची एक मेंटॅलिटी असते, दे नेव्हर डिस्करेज यू. तुम्ही असं का केलं असं का केलं म्हणून कधीही डिस्करेज करणार नाही, परंतु इव्हेंच्युअली त्याचा इफेक्ट कुठे होतो, तुमच्या मार्किंगवरती होतो. विद्यार्थी लॉ सांगतोय आणि त्याच्याकडे Dare Act नाही किंवा मला तो प्रोव्हिजन दाखवा असं मी म्हटलं तर तुमच्याकडे काहीतरी असायलाच पाहिजे ना. ॲक्च्युअल कोर्टामध्ये काय होतं की ज्या वेळेला मी एखाद्याला रेफरन्स करत असतो त्या वेळेला तिथला जो लॉ क्लर्क असतो तो त्याचीच ना कॉपीज देत असतो. त्यामुळे पुढच्या वेळेला ज्या वेळेला तुम्ही मीटिंगमध्ये पार्टिसिपेट व्हाल, पहिलं काम जे असेल तर ते म्हणजे ऑथेंटिक Dare Act तुमच्यासोबत असणं गरजेचं आहे. लॉर्डशिप्स विचारू दे न विचारू दे, तुमची ड्युटी आहे की यू शुड कॅरी द Dare Act विथ यू. Rest out, the performance was beautiful. Performance was almost near to perfection, and I believe that my students of this Shahaji Law College would excel further and bring the laurels to this institution as many of your predecessor students have done. Best wishes.
whatever the remarks I want to be suggest, only the thing is that Honorable Principal Dr. P.B. Patil sir has been disclosed the same thing. The bare act must be there because whatever the questions I have raised, it directly related with the bare act itself. But on some point of jurisdiction, not satisfied from our point of view. But in due course of time, as we have been sure that in the coming days you are supposed to be rectify that. That's only the suggestion because Madam also stated the same thing. Council of Education's Shahaji Law College, Kolhapur organized the internal moot court competition, and in this competition, near about 200 participants have been participated. 50 students participated in Marathi and 100 students participated in English one. And yesterday we have assessed the students in 7 moot courts hall, where the alumni judges, the senior advocates of the bar, assess the students along with Honorable Principal and myself as the supervisory authority, Honorable Principal, and coordination from my side. When we have been asked to the principal that, sir, we are supposed to be organized, he immediately gives the kind consent that yes, sir, we are supposed to be, and make sure that this particular event must be in the larger scale. कारण काल संध्याकाळी मी सरांना आमच्या ऑफिशियल ग्रुपमध्ये जेव्हा मी आपल्या रील दाखवल्या, सरांनी त्यांचा जो भाग होता आम्हाला द्यायचा बुस्टिंग मॉरल ज्याला म्हणतो, की त्यांनी त्या पद्धतीने सगळ्यांसमोर आम्हाला उद्युक्त केलं आहे. वी हॅव बीन बुस्टेड अवर मॉरल ॲज सच. फॉर दॅट थिंग आय पर्सनली बीइंग ए सिनियर फॅकल्टी आय express my profound gratitude to the Honorable Principal Dr. P.B. Patil sir for giving the kind consent and giving the entire the financial and infrastructure wise help to the people, and because he is supposed to be backbone from the day he joins as such one. कारण सरांनी जेव्हापासून चेअर घेतली आहे त्यापासून तुम्ही त्याचा विटनेस आहात की आपण जरा वेगळ्या लेवलवर चाललाय. मी परत एकदा आदरणीय प्राचार्य डॉक्टर पी.बी. पाटील सर यांचा इथे आभार व्यक्त करतो. काउन्सिल ऑफ एज्युकेशनचे सगळेच पदाधिकारी आमच्या पाठीशी असतात, त्यांचं देखील मी मनापासून इथे आभार व्यक्त करतो. 7 जे अलुमिनाय जजेस आमच्याकडे काल आले होते त्यांचं देखील मी मनापासून आभार व्यक्त करतो की इन स्पाईट ऑफ देअर बिझी शेड्यूल आदित्य रक्ताळेसारखे जे हायकोर्ट लिडिंग प्रॅक्टिशनर असू देत, चुरमुंगे साहेब असू देत किंवा सौरभ तांदुळे असू देत, हे लोक देखील आमच्या त्या एका हाकेला इथं आलेले आहेत होते, त्यांचं देखील इथे मनापासून मी आभार व्यक्त करतो. आजच्या फायनल मोट कोर्ट कॉम्पिटिशनमध्ये मॅडमला आम्ही फोन केला, प्राचार्य सरांनी फोन केला की इमिजिएटली येस आय लव्ह टू कम ओव्हर देअर असं म्हणून आमचा उत्साह वाढवल्याबद्दल मॅडम तुमचे खरंच मनापासून आभार. फॅमिली कोर्टात जर तुम्ही नुसता मॅडमचं नाव जर घेतलं पेडणेकर मॅडम, तर तुम्हाला त्याची प्रचिती लक्षात येईल की हाऊ शी इज बिझी अँड हाऊ शी हॅज बीन दी पॉप्युलर इन व्ह्यू ऑफ इंटेलेक्च्युअल आस्पेक्ट इन द फॅमिली कोर्ट ॲज सच वन. आणि आपण वेळ दिल्याबद्दल मॅडम तुमचं मनापासून आभार व्यक्त करतो. माझे जी स्टुडंट पार्टिसिपेंट्स जे होते ते 200 पार्टिसिपेंट्स नॉट अ जोक वन, आणि त्या 200मधून तुम्ही फिल्टर होऊन जे आज आलेले 14 लोक यांचे देखील मी मनापासून आभार व्यक्त करतो. इनफॅक्ट जरी इंटेलेक्च्युअल ॲक्टिव्हिटी जरी असेल तरी तुम्ही लोकांनी 1700मधून या एवढ्याच लोकांनी पार्टिसिपेट केलेलं आहे. हे नसेल थोडके ज्याला म्हणतो आपण, you are really deserve for the congratulation from the entire the coordinating the team as such from the leadership point of view. आणि जे आमच्या मागच्या 20 दिवसापासून माझी टीम काम करत होती यांचे देखील खरंच मनापासून आभार. निरंजन असेल, हाक दिले की बिचारा तो तयार होत असतो, त्यांचे देखील मी मनापासून आभार व्यक्त करतो. माझा टीचिंग स्टाफ मागच्या काल जरी आम्ही 2 दिवसापासून हे करत असतो तरी माझा सर्वच टीचिंग स्टाफ, मला साधे मॅडम असू देत, कल्याणी मॅडम असू देत, 1-2 नाव घेऊन मी कमी करत नाही, सुचिता मॅडम असू देत, कल्याणी मॅडम असू देत, या सगळे मॅडम आणि सर या सगळ्या लोकांनी आम्हाला एका वेगळ्याच याच्यात दिले आहेत आणि त्या अनुषंगाने मी सगळ्या माझ्या टीचिंग स्टाफचं देखील इथे आभार व्यक्त करतो. रिझन मी प्राचार्य सरांना अशी विनंती करतो की जो रिझल्ट आलेला आहे त्यांनी तो डिस्क्लोज करा.
मी जजेस केले त्यांना म्हटले Second runner-up, because we have two runners-up. Second runner-up is Rushita Tarandi.
आहे इथे रुचिता आहे नाही.
First runner-up is Siddhi Khadavkar. And the winner is Tushar Jagtap. Congratulations to all.
विनर टीम अशी आहे, आम्ही फक्त पकडूया. पहिला